This is the Mobile Home Park Lawyer Podcast with Ferd Neiman. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd Neiman.
Welcome back, Mobile Home Park Nation. Ferd Neiman here again. Today I have another episode of the Mobile Home Park Lawyer Podcast. Got a familiar guest for you here, my law partner, Jonathan Gilmore. We're going to talk today about a fairly complicated topic. So if this is, if you're driving, you probably can't take notes. But this is probably one where you want to take notes. Or at least listen to it twice. Sometimes I talk a little quickly, so you probably can't listen to me on 2x on this one and keep up. But seriously, we're going to share our screen a couple times as well, so there'll be some visuals. You can listen to this on the audio, but it might be good to go to our website or YouTube where you can see the video if you want. And so to dive into without much further ado, the topic of today is a tenant in common, a TIC drop and swap, as we call them. And basically, this is a way to do a 1031 exchange, and in a way that different members of the LLC can separate and go different ways and both still preserve 1031 potential. And just, high level, 1031 exchanges, or sometimes called a Starker exchange, a like kind exchange, from Section 1031 in the Internal Revenue Code. Basically, if I buy a mobile home park for $1 million and I sell it for $2 million, I've got $1 million gain. If I depreciate the first $1 million down, well, then I have more gain. I'll have cost recovery recapture, but I'll have gain. If it's more than 365 days, it's long-term capital gain. If it's less than that, it's short-term gain. And different tax rates, there's a long-term gains are going to be taxed more favorably, meaning less tax rate. But in order to do that, I need to sell real property and buy real property. So if I sell the $1 million property, I need to buy at least I sell for $2 million. I need to buy a new property for $2 million or more. It's got to be investment property. It can't be a personal residence. It can't be a second home that you have personal use of. It can't be a baseball card collection. That would be personal property. So how do we do it if we want to separate ways? If it's Ferd and 4 other investors, and the 5 of us want to separate, but none of us want to take the tax hit, how do we do it? Well, we do it in the form of a drop into a tenant in common structure, and then we can all 1031 via a qualified intermediary. And those timelines, high level, you got 45 days to identify replacement properties. You got 180 days, not 6 months, not business days, 180 days to purchase replacement property of greater value. If you take some cash off the table, it's taxable as boot. You also have to replace your debt. You can't just get rid of debt and buy the next property cash. You got to have more debt and more purchase price in order to properly pay zero at the time of the sale or at the next tax return filing. So there's a little prelude to the easy stuff on 1031. Now I'll bring in the big guns here, Jonathan, and you can tell us the hard part, and I'll try to keep up. So hand it over to you, man.
Well, hey, you just conceptually, thanks for having me on. It's good to be back. Conceptually, you nailed it. We're trying to, you said several times, what is property that you can exchange? It has to be investment property. One of the properties you cannot change in a like kind swap is partnership interests. So the structure that we see a lot of our clients having before the sale of a property is they've got, limited partners. There may be our client may be the GP, but at some level there's an investors LLC, right? So there's an investment group, and one of those investors wants to go a different direction, like you said. They have partnership interests. They can't just get cash at closing and then go. They have to convert that partnership interest into a real property interest. And they do that, like you said, by dropping down, if you will, that interest into a real property interest as tenants in common. So like tenants in common, and we talked about this in previous podcasts, but it's a type of ownership in real property where all the owners have a percentage of ownership in the property to possess the entire property. In other words, one owner as tenant in common is 75%, and the other one's 25%. That equals 100%. They both own the property with their respective percentage interests. So we have to talk about, what we're going to talk about today is, how does that happen? How do we get there? Well, and we've got a couple of examples we'll pull up here in a minute, but the way we do it is conceptually is we have to figure out the amount that the new partner is going to have in the real property, or excuse me, the partner is going to have in the property when they become a landowner. That's basically what's happening. They become a landowner. So we have to figure that out. There's an economic component on that. A lot of times our clients have already figured that economic structure out, which is, look, if you were a partner in this entity and you just got cash, what's that look like as far as real property interests when you become a tenant in common owner? And so a lot of times that
can I jump in on that? Because that's,
yeah.
I know you're familiar with it, but for our audience, it can be pretty complicated. So let's say it's you, me, and Jay, and we own a piece of real property and we're 1/3 partners. Okay, that's generally pretty easy. In this, my prior example, if we bought it for $1 million and we sell it for $2 million, we have $1 million gain. If we have $500,000 mortgage, let's assume there's no commissions or legal fees or closing costs for easy math. There's $1.5 million of net proceeds if we sell the property. So if we're all willing to just take our money and retire, then we're not going to buy another property. Well, then it's pretty easy. It's 1.5 million. And if we're all 1/3 partners, we each would get 500,000 cash. But in the event that we're going to continue on the party, but we don't want to all buy the same asset together, we want to buy our own assets, then we would each get an interest that shows, 33 1/3% of the land. So in a 3-person partnership like that, it's pretty simple. Where it's complicated more so in a syndication is if there's hurdles. And if there's hurdles in the syndication where let's say that the GP gets 30% promote up until a 15 IRR, and then it goes to 50% promote. Well, if the net sales price in this example of 2 million leads to an IRR that is above 15%, then the GP is going to have a 30% clip up to the 15 IRR, and then a 50%. Well, you need to basically assume like it was a sale on that day, and then you do the math in the Excel formulas and you divvy up what the net proceeds would be, and that is out of the total pie. And if, let's say in this example of you, me, and Jay, you guys were both LPs and I was the promoter, and at the 2 million price, my share of the proceeds would have been 50%. Well, I would have then got 50% of the proceeds. So, and you two would have got 25 and 25. So at the time of the TIC, you need to own dirt in your own name. And of course, you're going to create a new LLC as a special purpose entity. And then Jay's going to do the same, and I'm going to do the same, but you're going to own dirt in 25%. And as I think it was episode 112, we covered a tenant in common with a roll up in the syndication. This is almost like the inverse where we're dropping down, and you're going to actually own real property. And there's some hurdles with that and some gotchas that we'll cover. But I just wanted to clarify that, divvying up the economics is vitally important, and it's going to be based on the constraints of the in-place operating agreement. And I know we commonly use the term partnership interest, but the precise vernacular would probably be a membership interest in a limited liability company that is taxed as a partnership. And that is like a partnership interest. A membership interest is not real property. So this TIC mechanism is how we convert it into real property, so as to make it proper and ready to buy more real property and to effectuate a 1031 exchange. That's right. And might be best if we want to pull up that ownership structure now, share your screen for the pre-drop. We can kind of show, what it would look like before the drop. There we go. So this is the pre-drop, and there's a lot of white space in here. That's because we're going to fill it in for the post-drop. So, if you're watching along here, we've got, your investors LLC, and we have 2 members, Class A member, Class B member. In this instance, we're going to have the drop come out on the Class A member side, and it could be the GC side. A lot of our clients have the Class B members, and maybe there's an investor that wants to TIC drop out and go their separate way. But those are the owners of Investors LLC, and as you can see, Investors LLC owns 100% of Homes LLC, which owns the mobile homes, and then 100% of the Land LLC. And currently in this model, Land LLC owns 100% of
at the bottom of the screen, land located at 123 Anytown, USA. That's the actual real property. That's the dirt. So that's what it looks like before the drop. And that's your standard kind of formula we see a lot with a lot of our clients. If you look at now the ownership structure post drop, we'll see what it'll look like if a handful of investors, in this case from the Class A side, want to go their separate ways. We still have the Class B members, which still owns their percentage interest in Investors LLC. Investors LLC now owns 100% in Land LLC, but as you can see, Land LLC in this, it only owns 42.5% of the dirt because we have, based on the economics that you just talked about, we have figured out that this is the percentage structure that the Class A members who are going to drop their interests out are going to take in the land. So in this situation now we have MHP Land 2, Land 3, Land 4, Land 5 LLC, and just your original Land LLC, all totaling 100%. They are now all owners.
And let me jump in here on this so that in this example, the Class A member was the general partner. There were 4 general partners. The 4 general partners now own dirt in their own name, quote, their own new LLC. But we kept, for this project, we kept the existing Land LLC as the existing landowner. We could have dropped it down into a new SPE on its own, but because this was a syndication, those limited partners are already bound by the operating agreement of Investors LLC, which also had a private placement memorandum and an offering memorandum that disclosed all the risks, roles, responsibilities of the general and the limited partners in the overall investment. So if you tick all those LPs out and you got 30 guys and gals and entities in there, you kind of lose the control of them.
That's right.
And it's hard to get them back. So if the goal is to let the GPs separate and take their money elsewhere, but still maintain control of the LP money, this is a way to do it. If you didn't want to tick out, well, then Investors LLC, the sole manager and member of Land LLC, could just do a 1031 in my earlier example for all $2 million. Here, the 2 million, you got about 800,000 and change going to the LPs. You got about 1.2 going to the GPs, and you could have 5 potential different 1031s, noting also that you can 1031 into more than one property. So you add it all up, you could have quite a few different properties here. Gets pretty confusing for the title company and the qualified intermediary and the buyer, because the buyer's going to be buying from who. But that's part of it too that I know we'll cover. But that was the reason why Land LLC in this example did not become a new entity. It's a TIC member. There are 5 members, excuse me, at the time of the drop. 1, 2, 3, 4, and the original land. For a total of 5. So that's how you can take it. And then if you tick in, let's say you're going to go buy instead of a $2 million purchase, you're going to go buy a $50 million property. Well, you've already got the TIC structure set up. You might be able to tick and do a joint venture or even a syndication with other entities or other individuals and have them be new TIC members in a different acquisition. If it's a syndication, then it would be like we covered in episode 112, where they may get rolled up at a later date into one entity. But once you're rolled up, you can't really, it gets messier to try to roll back out. And so you really want to plan this in the front end as much as possible. And it's a lot of work, you can tell. And
it is. It's lots of charts, a lot of work. Part of what, and we can talk about this with this on the screen. It's important is, like you said, not only on the investment side, on the PPM side, having authority, having disclosures ready, contemplating this potential event happening. Also, when you're negotiating the purchase and sale agreement, making sure that your PSA with the buyer has 1031 mutual cooperation language in there so that you can do this and you're not going to get any pushback. It's usually just one paragraph in the PSA. It's not too much. It usually just details that in the event of a 1031 exchange, parties will cooperate. It doesn't, you don't have to delay closing for this, but it allows the, in this case, the seller to say, hey, buyer, here's an assignment of our contract to our drop entities. and we're going to, engage in a 1031 exchange, and it really should be no big deal to the buyer that, because they've already been put on notice. This is a possibility through the purchase and sale agreement. You'd also reference the qualified intermediary and the title company. It's really important when we're, thinking about the drop structure that we loop in those parties as early as possible, just to let them know, hey, this is coming along, because with the title company, for instance, they have to revise the commitment. It's, to once we do the drop, basically, I'll just jump to how we do the drop real quick. The drop is a deed transfer, from Land LLC to these MHP Land 2, Land 3, Land 4, Land 5 LLC, where then Land LLC retains a certain portion, all is tenant in common. It's a deed transfer. Well, then that changed the fee simple ownership of the property, which is referenced in the title commitment. So there's time and turnaround with that. So you want to let the title company know as soon as possible that you intend on doing that, so that they're ready for it. And so that's very key, to communicate with the interested parties. I've had it happen before where I've been brought in the last minute and the title company wasn't even aware this was happening, and they're kind of caught on their heels. And so,
well, and that's why I want to add to that. That's why you want to make sure you let the buyer know on a regular basis, like, hey, we're going to have a TIC drops, that we're going to have an LLC change. So you have in the contract, but you let them know, because the deed's going to be different. The assignment of leases is going to be different. The bill of sale is going to be different. You may have to fill out several. You'll have numerous deeds. You'll have sometimes the title commitments that they can just make one title commitment, just because they're still selling only one piece of property. It's just different ownership. But you may have additional transfer documents that the title company
owner's
requires,
affidavits,
authorizing resolutions. Who's the signatory at the end of this rainbow? You got all these entities with upper tier entities. You got new SPs. And at some point you got to let the lender know, but we'll talk about that in a minute.
We will. And the author, you touched on it, authorizing resolutions. This is a connected dot kind of flow chart situation. Everyone saw the before and after. A lot of times there's several variations and iterations of that org chart, because it's kind of a negotiation of who's going where and how that's going to look. So that might take 4 or 5 different variations before you get to that final org chart. At that point, you then have to, as a lawyer, so what we spend a lot of time on, which is making sure that the resolutions authorizing not just the drop, but then the out sale to the buyer are all in line and in unison, and then sending those to the title company, obviously, to the qualified intermediary, so that they have the proper paperwork ready for the QI to take the proceeds at closing. And you kind of touched on those. That's actually for the drop, in anticipation of the actual closing. A lot of times, we can start talking about the lender here as well, but timing of this drop is crucial, right? I've had a CPA tell me one time, well, you really need to do the drop 2 years in anticipation to make sure there's no, IRS reclassification as, partnership interest, and thus losing the benefits that a 1031 exchange would afford. For the most part, drops happen 2 days or less before an actual closing. And one of the reasons is because you have to prepare for unringing the bell in the event that closing doesn't occur, which is very complicated. And it's not just unwinding it; it's unwinding it with authority. And a lot of times that authority comes from the beginning of the deal, like you said, with the PPM and operating agreement. So you have to make sure you're looking ahead. And sometimes you just don't have that ability to do so.
Well, let me. I want to add to that, yeah, because I think about it, if I'm the syndicator of a deal or just a manager of a project, let's say I'm the earlier example, I own 50, and or I think we did thirds, but say I own 50, you own 25, and Jay owns 25, and I'm the manager. I have control. In this case, I don't have majority vote, I guess, but I have control. If I tick out, how do I maintain that control? Well, I do via the tenant in common agreement, which is a separate contract that binds the tenant. Because if I'm going to give 30 LPs their own land, I don't want them selling it off, because just tenant in common 101, you could sell it to Bob. Well, now I don't know Bob. Maybe I don't want to be partners with Bob. But that's your right, unless you've contracted it away in their tenant in common agreement that says you can't sell it, or we almost sell together. So that's an issue. But when it's easy for a CPA to say, You have to do it 2 years before closing. Well, who knows when 2 years before closing? I own property right now. I don't know if when's 2 years before closing date. But in addition to that, if I tick it out, I got to have more management agreements. I got to have more insurance on the property. Presumably, my loan has a do not encumber or modify ownership or transfer or sale clause. So if I tick it out, I probably need the lender's permission. Well, a lot of lenders are going to say no way, right? Or they're going to charge you a bunch of fees to analyze it to then say no way. So I think in the real world, what happens a lot of times is people do it simultaneously at closing or the morning of, and it's just basically record this, deed out, and the title company's got the new title commitment ready to go and owner's policy as if it's about to happen, and then the attorney, dutifully crafts a closing construction letter, laying out the order of operations, and sharing all the requisite documents, many of which we've already covered. But I think practically, 1 year is safer than 2 days, and 2 years safer than 1 year. And the safe being the IRS. If you do this 2 days before closing, they're going to say, why are you doing this? It's almost like you're trying to do a 1031 exchange to not pay tax, and they don't want you to do it. So there's some IRS rules have a safe harbor, meaning like a bright line test. If you do this, like if you're self-employed and you pay your own taxes, one of the safe harbors is if you pay a quarterly estimate at least as much as you had to pay last year, you're not going to hit with penalties and interest. So if I'm usually pay $1,000 a quarter, if next year, if I pay $1,000 a quarter, I'm probably safe. I can't pay $900 a quarter, and I can't pay zero. But there's no safe harbor here. It's more, I don't even believe there's private letter rulings. There's the Rev Proc we've talked about before. What is it?
2002-22, which it lays out the 15 factors for what would be a safe harbor tenants in common 1031 exchange. But that's not code. That's not codified either. So you mentioned the tenant in common agreement, which we talked about in a previous podcast. That's kind of like the operating agreement for the real property owners. But it has to follow certain rules and guidelines. There's preferred ways to draft that, and we have several different iterations that we use. But yeah, to that extent, you have competing interests, right? You need to do the drop because you have to do the drop business wise. There's business reasons for doing it and economic reasons for doing it. The competing interest maybe being the tax component of it and the timing as well. So, and also, like you said, there's a control component of it as well, which is a TIC agreement. Once the drop happens, is in place, it governs the TIC owners until closing, right? And everyone goes their separate ways. But if closing doesn't occur, do you roll it back up? Do you have the ability, as say the GP, I'm using that term, or the manager, do they have the ability to roll it back up, or are you just stuck in that kind of that setup, right, until the next sale, which is oftentimes why drops happen right before closing. So
exactly. All right, what are we missing? There's more complexity to this, I'm sure, but I mean, in general, you've got a detailed checklist of docs and things docs and steps that different parties need to do. You want to hit on some of those?
Yeah, a lot of them we've hit on already, but the org charts that you just looked at is usually key. That's like almost first step, right? What are we doing? Where is this ending up? So we usually prepare those first. The consent resolutions for the drops, in other words, the entities that are approving the drops and the managers of those entities approving the drops, those have to get prepared. The tenant in common agreement, which I just discussed, that needs to get prepared. The drop, what I call the drop deed, this is the transfer from Land LLC to Land LLC and the other new tenant in common owners, that needs to be prepared. Notifying the investors of, hey, this is what we're doing, this is what's going to happen. The lawyers oftentimes don't prepare that, but that's generally addressed in our checklist. You have to be prepared to form the new entities. In states like Missouri, you can form the drop entities in a day. Some other states like Pennsylvania take longer. Some states take, they're out of your control longer. So it could be weeks before you can form the SPs, just depending on the state. So you want to make sure you're in front of the curve with those. If you form them too early, you need to make sure that you have certificates of good standing for the actual out sale to the buyer. You have to have those in there.
That's one of the annoying things. So I've had to deal with is, so you want to create your LLCs in time, but if you create them more than 30 days in advance, the title company is going to make you go back and get certificates of good standing that you're still in good standing 30 days later. So it's like, good grief. Just went through this process, just paid the fee. Now I got to go pay another fee to say that I'm still in good standing. I haven't even used the LLC yet. It doesn't really take any real role in life until closing, but
that's right. Yeah. So you want to make sure that it hasn't fallen out of favor in 31 days. You want to, like I said, notify the qualified intermediary, send applicable documents to whatever they need. One of the items that we do is we prepare the signature blocks for all of the closing documents. A lot of lenders, for instance, will require that. They'll say, who's signing? Okay. Deferred signing. Okay. Deferred signing is what? Oh, authorized signatory. Well, what makes him the authorized signatory? So that's the authorizing resolutions, which kind of ties and works backwards and say, this is how he has the authority. And then you just pre-prepare all the SIG blocks. That happens. And that also saves a lot of time. If we're able to do that, some lenders miss it and papers flying, the day before closing a lot. And so reviewing the existing PPM or operating agreement, just to make sure there's authority to do that. That's one of the things that we can assist clients with. Then we have to prepare bills of sale and assignment of leases or partial assignment of leases from Land LLC to Land LLC and other TIC interest owners, because they are now part of the deal, right? As owners of the property. Let's see, what else do we do? So that's kind of in preparation of the actual drop. Those are I'd say a non-exhaustive list of kind of the things that we do and we prepare and we analyze before the drop. Then you have the closing documents. So once you have that step, you then basically replicate most of those documents for closing, right? Assignment of leases, bill of sale. Now you have the out sale deed. So the grantor for the out sale deed are now all the TIC members, right? One thing to note that where this has gotten interesting as well is we've actually been doing this sometimes before, only to find out that the buyer is also establishing TIC members. So we'll get all of our paperwork done, we'll get the deed done, we'll be kind of moving forward, only to find out, a handful of days before closing, the buyer will come to the table and say, oh, hey, by the way, we also have TICs because we're syndication and we're bringing in money. So that then triggers a new commitment. That triggers modification of the documents. That triggers all sorts of things. So communicating with not just the QI and title company, but also in a way that's proper and timely, communicating with the other party. There's nothing wrong with saying, sending them a draft of the assignment, contemplating the TIC, the PSA assignment, or the contract assignment, saying, oh, hey, by the way, we're going to assign this from Land LLC, if you will, to Land LLC and these new TIC members. Sometimes they'll reciprocate. They say, oh, yeah, hey, thanks for sending that. We're also going to do the same thing. So then we can inform title and say, only, renew the commitment one time, right? It saves time. And if you're trying to do this 3-4 days before closing, kind of up against it. I guess I've covered most of what we do for the closing documents, the communication required, and then just really anything else that's required for closing, making sure that it now comports with the entities that are involved with post drop.
Yeah, you can make sure you get the right entities as borrowers and as guarantors and all that kind of stuff. And then if you're the, that's kind of it, so to speak, on the law side. If you're the syndicator, in your selling, you need to communicate with your investors. Perhaps a letter that says, dear team, we sold the deal, we made $1 million. Because I'm trying to help you guys not pay tax, I'm going to do a TIC drop swap and allow you to 1031 your own, or I'm going to now take your 1031 money to this new investment. Here's your net shield. Here's your investment return and your pref and your hurdles. Now, here's what they are in the future. And if it's in a new entity, what that looks like, if it's in a new project, and just make sure you've got the authority that you're using. Make sure you get your math right. Make sure you get your splits right. You don't want to get in the middle of, being accused of doing it wrong. You can offer them their own counsel. Sometimes you can say, hey, we're all going to go to the next party and I'm the manager, I'm taking all of our funds, but I still have to abide by the operating agreement. Or you may say, the next deal's not big enough for all of us. I'm taking out my share as the GP and I'm going to buy it on my own. And here's your money back. And then, here's your money's going into the QI, because the QI is the guy that holds your funds at closing. You don't get to touch it. So if you put it in the QI, you don't get that money back until 180 days expires, or hopefully, and before that, when you buy a deal and it goes into that deal, and you still don't get it back, but at least you get a deal. So lots of moving parts in all respects. But again, if you do the tick out early, you need lender permission, and you need to make sure your insurance and other things buttoned up. I mean, if you do it the day before, you probably still need lender permission, but if it's simultaneous to close, the lender is probably not going to care. Or by the time they recognize that they've already got their money. I'm not going to advocate for that, but practically that's how it seems to happen, that the title company is, the lender doesn't even hardly know. They just, hey, we request a payoff, we get a payoff, the payoff's 500,000, boom, you got paid off. And they get paid before the deed swap. So they're not,
in the
theory, they're not harmed.
That's right. That's right. And the title commitment, it's a requirement to satisfy and release the mortgage and to pay it off. So closing doesn't happen but for that. So
that's right. All right, Jonathan, great stuff. Anything else we missed? Any other comments?
That's it. That's what I got. Thank you for having me on. I appreciate it.
Yeah. Should I hit record now?
Oh. Okay.
You know me too well. Thanks, man.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Neiman. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.